Trooper Buchnick or Trooper Prochnow how he extracted the tests, despite the fact that it was done by a friend of his in the federal government. During the federal proffer, Brian Higgins admits that he had been served with a preservation order, and the Commonwealth told him he could destroy his phone despite the order. He then drives to a military base on Cape Cod, opens his phone, breaks the SIM card, and throws the phone away.
So the Karen Read case is still in the pre-trial hearing stage. After this video, I will go into what is about to happen next in the trial.
That he had received some text that concerns him as an explanation. And after that, Brian Higgins changes his phone number and changes his cell carrier. In short, he was present that night, he had a motive, and there is plenty of consciousness of guilt cover-up evidence with regard to Mr. Higgins. Moving on to Colin Albert. Shortly before January 29th of 2022, Colin Albert lived with his parents, Christopher Albert and Julie Albert, on John O'Keefe's street, just 2 doors down. We have evidence of bad blood between Colin Albert and John O'Keefe.
Just first, again, what the case law requires is evidence and not just mere speculation, or saying that you have evidence is not actually evidence. I do find it somewhat interesting that Mr. Yannetti wrote apparently 4.5 pages of notes, but didn't have time to write a motion to admit the evidence that he claims that he has. He references in regard to third-party culprit Dr. Sheridan, who indicated that the injuries are consistent with the fight. He's the same doctor who indicated that the injuries on Mr. O'Keefe's arm were consistent with the dog bite, which was then refuted by the DNA findings from UC Davis, as well as the fact that the injuries are only on one side of the arm. And last time I checked, dogs have teeth on the top and the bottom, and there's no injuries to the bottom.
So as you can see in this video, you see Karen Read's attorney David Yannetti, who is presenting what is called the alternative suspect theory. The reason that he's doing that is because he wants this evidence to be allowed to be brought up in trial, so that he can argue that rather than his client Karen Read being responsible for the victim in the case passing away, it is 3 alternative suspects. Now, for those who don't know, this is a case in which Karen Read dropped her boyfriend off at a party. The party happened to have police officers there because her boyfriend was a police officer, and he ended up passing away that night, and she was suspected of causing it. However, the defense attorneys and even the evidence in the case indicate that there may have been foul play inside the house where Karen Read was not present, and that she may have been framed by the police itself. Now, the reason that the application had to be made to allow the alternative suspect is because sometimes certain evidence cannot be brought up in court unless the judge agrees. Therefore, there'll be a pre-trial motion to see what can be let in and what may be kicked out. My observation of the case so far is that I'm quite surprised at the caliber of attorneys Karen Read has. She has 2 very experienced and incredibly articulate, well-spoken, engaging lawyers, David Yannetti and Alan Jackson. Typically, when a person is at trial, when you've got a defendant, they struggle to even get one competent attorney or one impressive defense lawyer. She's got 2. So already she's probably on the right track. And in addition to that, a lot of the evidence in the case indicates that there may be exculpatory evidence which goes to show that she may not be guilty of this crime. Obviously, it depends on what else comes out in trial. And you can even compare the tone, the posture, the way that David Yannetti speaks in such an engaging way, which is the quintessential defense attorney. Compare him compare him to the way that the prosecutor expresses himself and see if there's a difference. For example, I've noticed that the prosecutor constantly says, those are called filler words, which he uses consistently in his speech. That is not ideal for creating a very engaging narrative with a jury and holding people's attention and being able to pull them in. So it'll be interesting to see how things go when the trial proper starts next week. So make sure to like, comment, and subscribe.